In Irish law, a right to reside in a house and a life interest in property are distinct legal concepts with different rights, obligations and implications. And in this video I'm going to look at the difference between a right to reside in a house, perhaps for a lifetime or perhaps until somebody gets married, and a life interest. So, a right to reside. A right to reside is a personal right granted to an individual to live in a specific property. It does not give ownership or control over the property, and it is limited to the individual or individuals specified in the grant or in a will. So some features of a right to reside would include it's non-transferable, it's typically personal to the beneficiary and cannot be sold, assigned or inherited. Secondly, limited use. The right is confined to occupation of the property. The individual cannot lease or mortgage it. Conditions. It may be subject to conditions such as being revocable upon specific events. For example, a marriage or moving to a nursing home. So a person could have a right to reside in a house pursuant to a will until they get married. No income right. The beneficiary cannot derive income from the property, for example, by letting it out. Examples often used in family arrangements where one party wants to ensure that another, for example a surviving spouse or a dependent, has a place to live but does not want to transfer ownership. So the right to reside contrasts with a life interest. The life interest is a broader right giving an individual, that's the life tenant, control over a property or assets such as income or use of the income for the duration of their lifetime. Ownership of the property remains with another party, the remainder man. Features of the life interest include control. The life tenant can occupy, use or rent the property and derive income from it. Obligations. The life tenant is usually responsible for maintaining the property and paying property related expenses, for example insurance and tax. Termination. The life interest ends upon the life tenant's death, at which point the property passes to the remainder man. Alienation. While the life tenant cannot sell the property outright, they may be able to assign or sell their life interest under certain conditions. For example, it's common in wills and trusts where someone wants to provide for a spouse or a dependent during their lifetime but ensure the property ultimately passes to another, for example children from a previous relationship. So the key differences: right to reside and life interest. The right to reside is personal to a personal right to live in the property. The life interest, on the other hand, is a proprietary interest with control over property or income. The right to reside is non-transferable, whereas the life interest is transferable under certain conditions. The right to reside does not give any income rights, whereas the life interest does. The obligations under a right to reside are minimal. They may just pay utilities but not taxes, and the life interest owner is responsible for maintenance and taxes. In relation to ownership then, the right to reside does not affect ownership, whereas the life interest coexists with the remainder man's ownership. So the practical implications then: the right to reside, it provides limited security, often used for dependents where there's no need for broader control or financial benefit. A life interest, on the other hand, offers greater security and control, and it's often used in estate planning to balance the needs of different beneficiaries. I hope you find the video useful. If you do, I would appreciate if you hit the thumbs up button down below, and you may be interested in subscribing to my YouTube channel. Thank you very much.